All right, everybody, welcome to the next episode in the Olympus Wealth Strategies podcast. I'm your host, John Sidery, and very thankful to have another special guest on the podcast, Caleb Hollinger. He's a tax and estate attorney with the Friday Law Firm, excellent firm here in town, and he's going to share some insights on some estate planning and tax planning advice and maybe some pitfalls to avoid. So, Caleb, thanks for coming on board with us.
Yeah, John, thanks for having me. And I'll give you just a little bit of information about myself. Like John mentioned, I'm a trust and estates attorney at the Friday firm here in Little Rock, and I've been here, this is my 5th year. So time moves fast. And just, I'm from Sheridan, Arkansas originally, so small town, big dreams, but I'm familiar with the Little Rock area. I mean, that's what you did for fun growing up, is you would go to Little Rock. So familiar with the area, and a little bit more information about me. I had taken my bachelor's degree from Arkansas State University in Jonesboro, my Juris Doctorate from the William H. Bowen School of Law here in Little Rock, and my tax LLM or Master's of Law in Tax from the University of Florida in Gainesville.
So, for the Red Wolves, the Hogs, or the Gators?
Red Wolves first.
Okay.
And then the Gators second, which if you keep up with basketball, the Gators just won the national championship. They've got a really good golf program. They won it back in 23. So, and the football team is improving. So I do like to watch a lot of Gator stuff, no doubt.
And your Trojans just took it to LSU.
I know. I stayed up last night watching that game. It was a good job. Coach Curry's been doing a great job over there at the ELA program, and it was fun to watch. They made LSU sweat it.
Yeah. At least they rallied back and took them to game 3.
They did, and had a pretty good lead at the beginning of the game last night. But we're proud of the Trojan program as well.
So maybe you can give us a little bit of background as far as who the Friday firm is, and maybe a little bit more about your group.
Yeah. So the Friday firm is a full-service law firm, and we have represented businesses, nonprofits, government entities, individuals for well over 150 years. So one of the oldest firms in Arkansas. And we've got 94 attorneys across 2 offices. So we've got our office here in Little Rock, the original office, and we've got an office in Rogers. So we can service kind of the 2 primary parts of the state. I go all over the state, client meetings, the Delta, Northeast Arkansas, we're all over. And in our 2 offices, we've got a number of groups. So big firm, we've got groups that have specialties. For example, we've got our estate planning firm, our estate planning group, which I am a member of. And we've got an employee benefits ERISA group. We've got an M&A group. We've got litigation groups, which would include commercial, railroad, and just general litigation. We've also have a healthcare and regulatory group and real estate group and public finance, of course. So we've got a breadth of knowledge and excellent attorneys that we could generally help you out with any problem that you've got.
Yeah, and I've always been impressed with the work that you all do for, obviously, all your clients, but the ones we have overlap with.
Yeah.
So maybe you could talk to us, obviously we're here and how it ties into financial planning, and estate planning is I think at the core of that.
Yeah.
So maybe Caleb, you can tell us, why is estate planning even important?
Yeah.
And maybe just some high level information before we dive deeper.
Sure. So in general, the process of estate planning basically deals with the accumulation, preservation, and distribution of your assets. Okay. And that's in contemplation of death or incapacity. But really, and that's just a 10,000 level view of estate planning, but really it's more nuanced than that. So when you think about estate planning, there's a number of different factors that you've got to work through, right? So that's income tax planning goals, transfer tax. And by transfer tax, I'm referring to estate, gift, and generations giving transfer taxes. There's also family issues. So are you dealing with children who are minors, maybe children with special needs, or maybe children who are just not good money managers? So that's an important factor. And then you've got to also look at the probate avoidance side of estate planning, which is worth the wait and the time to have an attorney help you out, because nobody wants to go through probate, and I'm happy to get into that as well.
So you mentioned something as far as, obviously there's multiple functions of estate planning. For people who are out there going, well, I don't know if I want to take the time or the money to sit down with an experienced attorney like yourself, and they go on, not knocking any company, but they go on, just use the main name, LegalZoom, right? They create themselves some generic estate plan. Mm-hmm. Do you ever see any pitfalls from that on the back end?
I do. And I'll give you a little anecdote. So here recently, I had a power of attorney come across my desk. And the power of attorney was prepared by a do-it-yourself. I'm not going to name the outfit, but and they were looking to invoke it for a particular purpose. And so I took a look at the power of attorney. And if you don't know anything about powers of attorney, generally you've got what's called a durable power of attorney or non-durable. And this particular power of attorney was non-durable. And what that means is when you have a durable power of attorney, that means it survives your incapacity. So if you executed it today and you became incapacitated 2 weeks from now, if it's durable, it's still valid. But if it's non-durable, it ends at your incapacity. And this particular individual was the attorney in fact under the power of attorney. And in that case, it was a non-durable power of attorney and the principal had become incapacitated. So we had to tell.
So the power of attorney is worthless.
It's worthless.
And there's really not much to probably do at that point.
You got to go to court. And that's the whole point of having a power of attorney, is to avoid having those guardianship proceedings. So that was an unfortunate result. And that's just something that can happen when you use these DIY softwares or agencies, is that you're maybe not getting that face-to-face or a full explanation of what you're executing. And they may have saved a few bucks on the front end, but then now they're paying for it on the back end.
Yeah, when it's in a very heightened emotional state.
That's right. That's right. And they're trying to get things done and help out their principal, which a lot of times is their parent, and they just can't do it right away. And I'll tell you another thing too with the DIY softwares is that it can create some inconsistencies across documents. So let's say you use one of these platforms for wills, and you've got minor children. Generally, in your will, when you have minor children, you'll name guardians for your minor children in the event something were to happen to you both. One issue that can arise with these softwares is that, let's say, wife names her brother and husband names his brother, and they both pass, unfortunately, pursuant to a common disaster. Well, whose document governs, right? Like, who's going to be the guardian for the minor children? And so that can arise when you use these platforms when you're not really aware of the distinctions and how those should mirror, because of what happens, unfortunately, if you pass away together. So that's just kind of another example of some problems. Another being is updates in the law.
Yeah.
And so generally, if you've got a good working relationship with your trust or estate's attorney, they're going to tell you, hey, here's what we're looking at. Here's the forecast. We think there may be a change here. It may be time to revisit your estate plan. You may not get that with these DIY platforms.
Yeah. And so outside of the DIY, what other pitfalls do you see maybe with people that you work with, have worked with, or just kind of general population?
So specifically with just, maybe, can you rephrase your question for me one more time?
Yeah, just maybe some common estate planning pitfalls outside of the DIY platform.
Yeah. So probably one of the primary ones that I see from time to time is clients have come in and they've executed a revocable trust. So in their mind, they're thinking, we're good. We're going to avoid probate.
Yeah.
But even the most detailed and perfect estate plan can go awry if it's not properly implemented. And what I mean is you've got to fund your trust. You can't just sign a document and declare that I've created a trust, all my assets are in that trust. So when you've got assets with title, particularly real estate or closely held business interests, you've got to either assign those over or make those made payable to your trust. They're like a transfer on death designation. That way the trust is going to be funded. If something were to happen to you, that way it can be implemented. So that's one pitfall that I see from time to time, that I think that most clients need to be aware that once you create a trust, you've got to continually fund that trust to give it meaning. Else then you're relying on what's called a pour over will to get probate assets into that trust.
So obviously a lot of moving parts that really is needed for a partnership like yourself.
Yeah.
To come in.
That's right.
As far as some other things, some questions that have come in, Caleb, maybe some common myths and misunderstandings. So you've talked a lot about, wills, trust, generation skipping stuff.
Yeah.
Can you just break those down at a high level on really what those mean?
Yeah. Who's
it for, and when they become relevant?
Yeah. So one thing that I see from time to time is the client will come in and not understand the distinction between a last will and testament and a living will. And so your last will and testament, that is a dispositive testamentary document that generally describes where your property will ultimately end up upon your demise. Conversely, your living will is a healthcare document, and it expresses your wishes for healthcare treatment in the event you can't make those decisions yourself. And so a lot of times there's confusion there with clients on what those documents mean, but they are separate. Another thing that I see from time to time are financial powers of attorney. And so that's a document where you name an agent, turned an attorney in fact, to make certain decisions for you. And it can be either effective immediately or upon your incapacity. So it's a pretty versatile document. And one thing that I see from time to time is that when you execute a power of attorney, so let's say you executed one in 2010, and you come to my office and we execute one today, if you do not revoke that prior attorney in fact, it's still valid. So you can have
Okay, so you could have two out there,
right,
and two could be stepping in, or at least trying to step in.
At least trying to step in. So it's important, if the client wants to, you need to revoke that prior attorney in fact designation. That way you're not having dual authorities. And that's an issue that arises from time to time. Another thing with the power of attorney is that it ceases upon your demise. And so I'll have a client come in and say, well, mom died and I'm trying to have access to her bank account. The bank won't let me. And I'm using the power of attorney, but they're not taking it. And it's because it ceases it upon your demise. So then really what you're looking at next is to see whether it was a probate or non-probate asset, whether you have to get a probate court order or letters testamentary to access an account, or if it's a trust account, then you just got to show you the successor trustee and you provide that information and you should be good to go from there. But that's a couple things that I see. Another myth or misunderstanding involves the fact that if you've executed a trust or will and you've got assets that have beneficiary designations, so think retirement accounts, brokerage accounts, checking or savings, certificates of deposit, etc. With those accounts, those are outside of the probate process, and unless they're either titled or transferred to the trust, they're not governed by the terms of the trust. So if your trust says all my property goes to my two kids, A and B, but the beneficiary designation says everything goes to B, that asset's going to B. And so
the beneficiary designation will rule.
That's right. It rules.
Okay.
It rules. And a lot of times you can have them structured where the beneficiary is the trust. That way everything passes. And in a good world, that's pretty proper, but it does depend on the circumstances, whether it's going to be an inherited like IRA, subject to all the RMD rules. You need to look at those things.
So maybe outside that nuance there, is it maybe a good practice or a consideration to have your trust as the designated beneficiary on like a standard investment account? That way, if you make any amendments to your trust, you don't have to worry about going in and updating percentages for different parties or charities.
Absolutely. I would say with any brokerage account, definitely have your trust as either the owner or the beneficiary. Because like you're saying, if you amend the trust, it still survives and it's still in the trust, okay? And that's important. And it makes it easier, as you're an investment guy, you would know, on the back end when it comes to dividing the trust assets pursuant to the terms of the trust, it's easier if it's in that trust. The attorney would give trustee instructions to the financial advisor, and then the assets would be split according to the terms of the trust. So it definitely streamlines the process.
Well, and I think maybe one other misunderstanding, Caleb, before we dive deeper is people think estate planning is for those who may have a significant amount of wealth. But I argue, and I would imagine you being the same camp, it's actually for everybody.
It is for everybody.
Because if you don't have an estate plan in place, is it right by saying that ultimately your estate plan is already out there? It's just deemed by the state you reside in.
That's exactly right, John. So even if you never went to a lawyer's office to craft your estate plan, you do have an estate plan. The state writes it for you, and it's called the laws of intestacy. And so really, estate planning is a proactive approach where you can actually alter, curtail what the state would ordinarily write for you to just really distribute your property however you wish. And that's important to note, that you've always got an estate plan, but you're always free to rewrite that estate plan.
Yeah. And people who have worked hard their whole lives, right? They've accumulated assets. They, regardless of the dollar amount behind it, right? They've worked hard to accumulate something. Why not ensure that your hard work is going to be passed on to the parties you want to?
That's right. That's absolutely right.
So something else as far as we had a lot of engagement from listeners who wanted some questions answered. Can you talk about when someone would actually need a revocable living trust? And we've kind of hit on the estate planning benefits being probate, but maybe we can talk about probate in a little bit more. And then tied into when someone would need a revocable living trust, another question that came in that was pretty common was, what does an irrevocable trust mean?
Yeah. So not necessarily everybody needs a revocable trust. So let's say you're elderly and most of your assets are in a brokerage account or retirement account. You don't have any real estate. You can get by and avoid probate if that's your primary goal. with the use of beneficiary designations, but you need to make sure that they are proper.
Okay.
And so you would, at least if possible, want to have contingent beneficiaries. I like to use the rule of 2. So for every beneficiary you have named, you should have 2 behind it. And that way you avoid having to go through probate, even though that is traditionally a non-probate asset because of an invalid beneficiary designation. So that's one way to avoid probate. And you're typically dealing with smaller estates. We also have a small estates affidavit procedure in Arkansas. So generally, if your assets are not worth $100,000, your probate assets, so it wouldn't include anything that's in a trust during your lifetime, you can bypass a full probate procedure. But that may not be available depending on the value of your probate assets. And so beneficiary designations are one way to avoid probate. But the revocable trust is really, it's kind of, it's a will substitute ultimately. And so it is an excellent way to avoid probate. And it should be one of the goals of every estate plan, because the probate process, it's lengthy. It's at least 6 months, and it takes considerable time and costs to facilitate it. And it also depends on whether the interested parties, so the beneficiaries or would-be or the heirs, agree upon the terms of the will. So there could be a contest. If they don't agree, then you can't get waivers and consents from the beneficiaries to expedite the probate process. So then a lot of times you're looking at a lot longer than 6 months. But yeah, a revocable trust is a good will substitute. And as I mentioned before, if it's properly funded, then you've got a great chance of avoiding probate with your estate.
So obviously, and so there's ways to avoid maybe contention, ways to avoid headache, time, and cost. And then what about privacy differences? Yeah,
so you hit on it. So with a probate proceeding, it creates a public record. And so unless you get those waivers and consents, you're having to file an inventory and accounting for the probate estate, which is going to list all of the assets. So you don't really have any privacy there. Conversely, a trust administration is generally, unless there's a contest or something of that nature, it's outside of the probate court's jurisdiction, meaning it's a private administration. Saves you time and money much quicker. And you don't have to worry about people perusing through public records to get sort of your private family information. So that's another benefit of a probate administration, is that it is private. So you don't have to worry about that.
So really for all those benefits, and like when I talk to people, sometimes those that maybe their kids are already fully grown, right? Maybe they don't have significant real estate. You're not obviously doing this for yourself.
Right.
You're doing this to make it easy for your heirs.
That's right. That's absolutely right. And I think that's something that's lost. And obviously estate planning and it can be a difficult topic. It's hard to think about what's going to happen after you're gone.
Well, sure.
And it's obviously stressful for your family members. You just lost a loved one, and now you've got to pick up the pieces of what happens with the asset.
In a very high stress emotional moment, you want to be able to step into something that is hopefully a source of comfort, which is ease.
That's right.
Yeah.
Absolutely.
So we've talked about revocable trust, Caleb. How about let's talk about, several people asked about what's an irrevocable trust.
Yeah. So an irrevocable trust is generally, it's a trust that the settlors or grantors, the people who create the trust, cannot unilaterally revoke or amend. And another misconception is if I set up the Caleb Hollinger Revocable Trust, upon my demise, that trust is still called the Caleb Hollinger Revocable Trust, although it is irrevocable, as I'm in fact no longer there to revoke it or amend it. And so that confuses clients from time to time. But yeah, with an irrevocable trust, it's generally the assets in it, at the point it becomes irrevocable, the basis, and we'll get into the basis planning, that's a good topic to cover as well, are generally frozen at that time.
Okay.
And the main takeaways with irrevocable trusts, it can be used as a wealth transfer tool, a valuable wealth transfer tool if structured correctly. But you can't amend or modify it generally outside of extraordinary actions, either court approval or all the beneficiaries have to come to the table. And so that can create some burdens, especially if you created an inter vivos irrevocable trust for transfer tax purposes.
So maybe just at a high level, an irrevocable trust, without getting into extreme minutia, most revocable trusts become irrevocable once those parties that created that trust have passed.
That's correct.
But if you want to create an irrevocable trust while you're alive, it sounds like that's more for a wealth transfer planning situation.
Yeah,
Yeah.
Exactly. And another important distinction between a revocable trust and irrevocable trust is that irrevocable trusts are separate taxpayers.
Okay.
And so once a trust becomes irrevocable, you've got to obtain an employee identification or tax identification number for that trust. You've got to file the 1041 each year for that trust. And I'll tell you, without getting too far, like you said, into the minutia, with an irrevocable trust, the income tax consequences, trusts and estates, for that matter, are subject to more compressed marginal tax rates. And so if the income that's generated by a trust, an irrevocable trust, is retained at the trust level, it reaches the top 37% federal income tax rate much more quickly than an individual does. So that's something to take into account. But
What is that, Caleb? Like $15,000 or $20,000?
yeah, it's like a little over $15,000.
Yeah.
Which
as opposed to the top tax bracket for individuals, you know, you've got to be a truly a top income earner in the country. Yeah.
That's right. And with revocable trusts, because they are revocable, the IRS views those as, in essence, alter egos for tax purposes.
Yeah.
And so you don't have to file a separate income tax return for a revocable trust. Rather, the assets that generate the income, that income is just reflected on your individual 1040, your individual income tax return.
So not a separate tax filing, and ultimately can keep your same tax ID.
That's right. That's right.
That's good info. So you had kind of alluded to this. So let's just dive into it. So the different states I've lived in, one of those was a community property state. And so I think that's a big distinction for people who, especially another guest we had on this episode, this podcast was one of the economic developers for Arkansas and Little Rock. And he talked about all the different people that have moved here from various different places. And we're seeing that more and more with the growth of the region. And so for people who maybe live in a community property state, maybe you can tell us what that means at a high level, and obviously what Arkansas is, which is not community property. There's different rules when it comes to if someone were to pass away and you get what's called a step up or a step two in basis. And maybe just tell us what that means, why it's important, and maybe some nuanced differences in planning that you get into with your clients to maybe help them make that the most effective way possible.
Yeah, I'll cover the community property issue first. And so when you deal with community property, basically in a community property state such as Texas, there's a number of community property states, but you generally, when you're married, any property you acquire thereafter is deemed marital property, which you've each got a 50-50 interest in, and it's almost kind of down the middle, split the baby. Arkansas is a community law, a common law property jurisdiction. And so really the judge has discretion in the event of like a divorce to distribute the assets. A lot of times it may be 50-50, but it's not like a 50-50 strict mandate. In Arkansas, we do have an act that allows previous community law jurisdiction individuals to come into the state to preserve that distinction if desirable, but you could also use trust to alter that community property jurisdiction. And with your question about the step up in basis. So generally revocable trust, as I mentioned before, they're an alter ego of an individual. And so when you pass, at that time, it transitions to a new taxpayer, as we kind of covered. But what that means is under the, applicable tax law. So if you're dealing with the Internal Revenue Code, you can find it under Section 1014. But when you receive property by inheritance, bequest, by reason of death of the decedent, and also from a revocable trust, you get what's called a step-up in basis in those assets. So to use an example, let's say that your mother acquired some real estate, we'll use nice round numbers, for $100,000. And she passes away 10, 20 years later, and that property is now worth $500,000. So you can see there's $400,000 of built-in gain. And so if you were to inherit that property from a distribution from a revocable trust or will, you actually get that property with its tax basis at $500,000.
So fair market value upon that person's death.
That's right.
Wow.
And so in theory, if the heir or beneficiary sold it the next day, it would wipe out the gain. So it'd be an income tax-free transfer there. Conversely, generally, if you gift property, and that's under 1015 of the Internal Revenue Code, you get what's called a transfer basis. So using that prior example, if mother transferred the property to you today, you would actually get the basis at $100,000 and not its current fair market value. So if you then sold it the next day, then you're subject to the $400,000 worth of built-in gain there. And so a lot of times this is kind of income tax basis planning, which is a paramount part of estate planning. It truly is. It gives you the opportunity to income tax plan where you can wipe out some of that gain. And so it may be worth holding on to highly appreciated assets and passing those upon your demise. That way you wipe out that gain.
Like you said earlier, the difference of revocable versus irrevocable, freezing the basis
That's right.
or not, right? So obviously if I give something away and it's out of my estate in an irrevocable trust, then that basis is what it is at that point.
Yep.
And then upon my passing, there's no step up there.
Yeah. Yeah.
So maybe tying it more towards, as opposed to property where if I'm the last survivor, right? We're both married. So if, pick on us, right? If we were to pass away first, is there a way for our spouses to get a full step up in basis on joint property?
Yeah.
Or it only be stepped up 50%?
So really, if that is the goal, one way to accomplish that goal, if we're dealing in trust terms, is to have a joint revocable trust. And if clients come into my office and they're married, I represent them both. So anything one tells me, I have to tell the other. But I'm always make sure one of the first things I discuss when discussing joint revocable trust is what happens when one of you passes. And really, one option is to have the joint trust become irrevocable, meaning that the survivor could not make changes to it. And one reason you might want to do that is to protect against blended family concerns later on down the road. Because what if that survivor remarries?
Sure.
And a lot of times, the one spouse that would pass away first would want the assets in that trust to inure to the benefit of the children of the first marriage. That's one way to accomplish that. But if there aren't really concerns about remarriage, but I mean, who knows? But one way to achieve your full 100% basis step up is just to have that revocable trust remain fully revocable when one spouse passes. That would ensure that all the assets receive a basis step up when one spouse passes, or at least half of the assets, whatever's included in their estate, okay? Yeah. And then the remaining assets would receive a basis step up upon the death of the second spouse.
Very powerful, and obviously not something you get with DIY software, right?
That's
there.
right. That's right.
You hit it. So let's jump right into it. Very common question here. Second marriages, blended families. You kind of touched on it right there, but maybe some important things to consider or implement for people who come into a marriage with children or assets from a previous marriage.
Yeah. The first thing that comes to mind is premarital agreements. And premarital agreements kind of have negative connotations in society, but really it's a contingency plan. May or may not ever be used, right? You don't really enter into marriage in contemplation of then getting divorced, or most people don't.
Right.
But, otherwise, why would you get married in the first place? But that is an excellent tool to delineate, here's what my assets are, here's what your assets are. And if something were to happen in this marriage, it's clear, cut and dry, like how everything goes. So that's one way to protect assets that if you've got a second, marriage and you've got children from the first marriage, that's one way to protect those assets is through the use of premarital agreements.
Does that also mean keeping accounts separate, or do people just combine accounts at that point for second marriages?
Generally, if you've got a premarital agreement and you want to keep stuff truly separate, it would be best to have a separate account, but you could have a joint account for joint expenses. And then generally in a premarital agreement, you would outline that it's not a waiver of the entire agreement, but that you are allowed to have joint assets. And if you do, then they will be split 50-50. But otherwise, anything that was yours going into the marriage, or hers or his or hers, vice versa, those would remain separate. But you're always free generally. You could put this in your agreements to provide otherwise in your estate plan, where you could leave most of your assets to your surviving spouse despite the premarital agreement.
And just a lot of things to think about and consider, and the tax ramifications of it, and what it looks like to the person and their family.
Yeah.
So we kind of touched on this. Another question that came in was using an attorney versus the DIY software. I think we've hit on that for everybody. There's obviously, you could tell, a breadth of experience with Caleb, the Friday firm, his whole group, and the benefits to utilizing somebody like yourself, especially with all the law changes, right? And things that you'll send me, different updates on law changes and the impacts of that. I just think that relationship becomes very invaluable,
right?
Just whether it be an attorney, versus using a robo-advisor versus a financial advisor, right? There's always the reason for having the human element.
Yeah.
Caleb, we appreciate you coming on. Any kind of imparting wisdom you want to leave our listeners?
No, John, I'm Thanks for inviting me again.
Yeah.
But if you've ever got any questions, feel free to contact me. Phone number, email, you could be able to find that pretty easily. It may be linked in the description here of this podcast. But yeah, I'm always happy to help and have a conversation.
Well, Caleb, we appreciate you coming on, man. And thank you, everybody, for listening. And we will catch you on the next episode.
All opinions expressed on the podcast by the host and guests are solely their own opinions and do not reflect the opinion of Olympus Wealth Strategies or Uptick Partners, a registered investment advisor. This podcast is for educational purposes only and is not legal advice and should not be relied upon as a basis for any decisions. The investments discussed on this podcast may not be suitable for all investors and involve risks that should be carefully considered. Listeners are encouraged to consult with a qualified financial advisor before making any investment decisions. Certain investments may require specific investor qualifications, which not all individuals may meet. Any funds or companies discussed are not a recommendation or endorsement. Guests in the podcast might be actual clients, but are not compensated to be on the show, and their experiences are not representative of all relationships, which might differ substantially.